Hi, I'm Simon Bennett from OMB Solicitors and welcome back to the OMB Law Board. Today I've got Harley Wilkinson from our estates team. Welcome back, Harley.
Morning, Simon. How are you today?
Fantastic. So thanks for coming back, Harley. Today I really wanted to dig into some of the myths around superannuation and estate planning.
Excellent. Well, I'm all about this one. I think when we're talking about wills, we're talking about estate planning, powers of attorney, every conversation around that space needs to include superannuation. More and more people are putting more and more money into their superannuation these days. And it's not as simple as I've done a will, I've named some beneficiaries, I'm distributing my assets according to that will, and that includes my super. That is not the case. Your superannuation doesn't automatically form part of your estate, which is what's covered by your will. Your superannuation is special. It's different. It is outside of your will. Now, a person's will is going to cover their personally owned assets, which will usually be the car, the house, bit of money in the bank, personal items and things like that. That is not your superannuation. As we know, you can generally access your super when you hit 65 or, if you're a little bit younger and you're retiring, or otherwise when you pass away. So those are conditions that you've got to meet. And it's for that reason, and because your superannuation is technically part of a trust or held on trust for you until you achieve those conditions, that you can't just access it immediately, right? So what we have for your superannuation and the way in which we deal with that is almost through a will that is for your super, specifically for your super. Depending on who your superannuation provider is, they'll use slightly different forms or words to describe how you can deal with that. And the very, very common one that we see is binding death benefit nominations, or otherwise beneficiary nominations, and that sort of thing. So that is the formal way in which a member of a super fund provides directions or instructions to their super fund.
So, Harley, are those directions contained in your will, or are they part of the super policy itself?
A lot of the time you'll find that there will be provisions in a will that touch on superannuation. But what's really important to bear in mind is that those provisions or those instructions in your will are not binding on the superannuation company. And really what that means is that if I say in my will that I want my super to go to my spouse and that's all I've got, the super company does not have to pay my super that way. But if I have a binding death benefit nomination that I've sent into my super fund, they've accepted it, and I've named my spouse there, notwithstanding what I might have in my will, that is exactly how my super company has to pay my superannuation.
So the binding nomination overrides what may otherwise appear in a will.
Yes, exactly. And that comes back to the importance of including superannuation in discussions about your estate planning, because you can appreciate the disappointment a beneficiary might have if they read the will and they see that they're named as a beneficiary of the super. They think, how good is that? I'm going to get a nice big payout from the super fund. But they later find out, actually, there was a nomination done after the date of the will, nominating someone completely different. You're going to have a very disappointed beneficiary.
Yeah, or a will which says, I leave everything to my partner.
Yes.
I'm expecting to receive everything, but unbeknownst to me, there's this binding nomination going elsewhere.
That's right. And I think what's good to point out here is that these binding nominations are quite unique and different from the will. I referred to them before as a sort of will for your super. But they're different in the sense that you can't just nominate any beneficiary under those superannuation nominations. You can only nominate superannuation dependents or your estate. And when I say your estate, that's just meaning that your super can be paid to your estate where your will deals with it. I mentioned superannuation dependents before, and it's just important to point out and explain who those people are.
What are they? Yeah.
So superannuation dependents are going to be a spouse or a child. It can also include a person with whom that member is in an interdependency relationship. And that's a bit of a confusing word. There's some confusing terminology there. And really what that's getting down to is where, excuse me, where there's some level of financial, domestic, or personal support that is being provided by one person to the other. So that could qualify some other person who isn't necessarily a spouse or a child as a superannuation dependent.
Right. So a bit of reliance financially.
Yes. Yeah, that's right. Okay. And it's those people, those superannuation dependents, who you can validly nominate in that nomination. So if I were to name you, Simon, as my superannuation dependent.
Yes, please.
Would be good, wouldn't it?
Fantastic.
The super company is not going to accept that. They're going to say that that is invalid unless you were living with me and you were looking after me and paying all my bills. You know, they might look at that a little bit differently.
Yeah, this is crazy stuff. You know, in a world where our super is increasing exponentially, huge amounts of wealth are being retained and placed in superannuation. If you don't deal with it properly, if you don't see someone who is an expert in estate administration and you don't deal with it in your will and through binding nominations, you could have major problems.
That's absolutely right. And I think what can be a really big issue in this space is where you might have your will, you have no nomination. And that's a really big problem, again, because the super company is not bound by the will. And if there's no nomination, they really have no instruction or no direction from that member about how their benefits should be paid, in which case the super company has to turn to the superannuation laws and the regulations and at the same time be guided by the rules of their fund about how and to whom your superannuation is going to be paid. It could be to your spouse, it could be to your kids, it could be to your estate. You don't know, and that's the issue. Yeah. And that's why we need those binding nominations.
Well, don't leave it to chance. Our OMB estate team are more than happy to help you with your planning for estates and your superannuation. And Harley, that's been really informative. So thank you so much for coming in and informing our viewers and our listeners today on what I think is an absolute risky area of estate planning.
It is. It's yeah. Thanks for having me, mate. It is a really risky area, but with the right advice, you know, you can set up the right estate plan and avoid those risks.
If you have any further questions for Harley or the estate team, please just drop us a line and we'll do our best to get back to you on them.